Welcome to the Courtroom Chronicles. This channel is dedicated to educational content based on real-life cases and true events. This content shared here is drawn directly from the actual case file, and no names, places, or items have been changed. However, the content has been carefully summarized and presented for educational purposes in a comprehension format to inform, enlighten, and spark meaningful discussions. Whether you're here to learn, reflect, or simply understand the real-world scenarios better, you're in the right place. We believe in the power of truthful storytelling to educate and inspire. Disclaimer: while all stories are based on real cases, they are presented in a condensed and structured format for clarity and learning. Viewer discretion is advised where necessary. This case is cited from the Nigerian High Court online file, which is public record. This is a case between Cityview Estate Ltd versus Ecobank Nigeria Plc court and parties. This case was heard in the High Court of the Federal Capital Territory, Abuja, before Honor Justice A.S. Adepoju. The plaintiff respondent was Cityview Estate Ltd, and the defendant applicant was Ecobank Nigeria Plc. Facts of the case: Cityview Estate Ltd, an estate development company, maintained an account number 0312010 with Ecobank Nigeria Plc with a credit balance of approximately $48.6 million. On August 26, 2015, Cityview issued transfer instructions for payments to contractors from this account. Ecobank failed to honor the instructions, citing a directive from the Federal Mortgage Bank of Nigeria, FMBN, dated January 6, 2010, requesting that the bank suspend all transactions on the plaintiff's account. The dispute stems from an earlier loan transaction between the plaintiff and FMBN involving a SWORT $502 million development loan, part of which, $201 million, had been disbursed through a now-defunct bank, All States Trust Bank. That disbursement and the financial aftermath following the liquidation of All States Trust Bank became the subject of litigation at the Federal High Court. Suit No. FHC ABJ CS 639 2009. FMBN filed an application for a Mariva injunction, asset freezing order, which had not been granted but was used by Ecobank as the basis for freezing Cityview's account. Claims and relief sought. Cityview sought declarations that Ecobank breached its contractual duties, orders compelling Ecobank to transfer specified amounts. It's $500 million in special and general damages for unlawful withholding of funds and reputational harm. Defense and preliminary objection. Ecobank argued that the suit was statute barred. The case constituted an abuse of court process due to a related pending matter at the Federal High Court involving the same parties and subject matter. The Mariva injunction application, though not granted, justified its actions. Judgment. The court dismissed Cityview's claims based on the following key rulings. The Mariva injunction application was only a notice and not a court order. However, Cityview's failure to challenge the pending application or apply to strike it out undermined its position. The action was found to be an abuse of court process, given that similar issues were already pending at the Federal High Court. As such, the High Court refused to interfere, noting the risk of conflicting judgments and jurisdictional conflict. The plaintiff's action was dismissed, and $50,000 was awarded as costs to the defendant. Who won and why? Winner: the defendant, Ecobank Nigeria Plc. Why Cityview lost? Abuse of court process. The plaintiff pursued a new action in the FCT High Court despite a related and ongoing suit in the Federal High Court. The judge held that this amounted to forum shopping and an abuse of judicial process. Failure to challenge the Mariva injunction. Although the Mariva application was not granted, the plaintiff failed to take legal steps to strike it out or clarify its impact, creating a procedural weakness. Lack of material distinction. The plaintiff could not convincingly demonstrate that the account at issue was outside the scope of the ongoing Federal High Court proceedings. Further legal analysis and prevention. How this could have been avoided. Proper jurisdictional strategy. The plaintiff should have confined its grievance to the Federal High Court, where the earlier and related case was being heard. Filing a parallel suit invited a dismissal for abuse of court process. Early legal challenge to Mariva injunction. Rather than suing Ecobank, Cityview should have formally challenged the Mariva application before the Federal High Court, particularly if it believed the basis of that application had been withdrawn or was no longer valid. Proactive legal counsel. Legal advisors to Cityview ought to have sought consolidation or clarification orders in the federal high court to avoid parallel litigation and conflicting jurisdictional outcomes. Banking contract enforcement. Ecobank should have sought formal clarification or court validation before relying on an ungranted Mariva application to freeze customer funds. This would have protected them against liability while ensuring due process. Thanks so much for watching, fam. I really appreciate you spending your time with me. If you enjoyed the content, don't forget to hit that subscribe button, drop a comment below, and let me know what you think about the case. I love hearing your thoughts and feedback. And hey, if you felt a connection or learned something new, give this video a like and share it with someone who might enjoy it too. Until next time, stay safe, stay real, and I'll catch you in the next one.